welcome to EconVersations. I'm your host, Dr. Dan Sutter with the Johnson Center for Political Economy at Troy University. The legal and court system underlies business in the free enterprise system. Alabama lags other states nationally in per capita income, and one reason may be our state's liability and judicial system. What does the evidence show, and what reforms might improve our state's legal environment for business? Joining me on the show this week to discuss these issues is my colleague from the Johnson Center, Dr. John Dove. John, welcome back to the show.
Thanks very much.
I want to start here before we get started our discussion here to point out that this chapter is actually a part of our Johnson Center's Improving Lives in Alabama
That's right.
volume. And so your chapters talk about the role of the legal system and how that might be important for business and prosperity in our state, right?
That's exactly right. Yeah, and it's really about the importance what the legal system does, and a legal environment is to create, at least we hope, create a system of predictability and stability, especially in judicial decisions and the way that the law is made, because it's really through stability and predictability in that legal system that we have that individuals are better able to make long-term plans and to really think about long-term investments in the economy with the knowledge that the law itself or rulings won't be arbitrary, so that it's easier to actually take on risk associated with business and entrepreneurial activity, and really through that then lead to long-run growth and stability or prosperity.
And we need to have both contracts and a way to enforce those contracts just in case the disputes do arise, and those are inevitable in business, right?
That's exactly right, and that's why really kind of cornerstone to all of this is to have that independent third-party arbitrator anytime that disputes do arise, whatever those disputes might be. And for us, what we generally think of is that third-party arbitrator is the judicial system and judges who sit there and, at least what we hope, act in an unbiased manner in order to come to a decision about who's in the wrong, who's in the right, and then rule based on that fact.
And enforce the law fairly. Now, of course, one of the ongoing issues in the United States has been the question of whether we end up having a judicial system that ends up imposing bad rules on business, or people refer to as lawsuit abuse or tort abuse. And so the whole issue of tort reform, of legal reform, and its importance for business has been talked about a lot over the last several decades, probably, right?
Yeah, exactly. It's become a huge debate, both in the policy realm. It's also become a very large debate in the academic literature. A lot of academics have tried to look at what impact do things like judicial independence have on a number of economic outcomes. What impact do certain legal rules have on a number of economic outcomes, whether they be things like business formation, entrepreneurship, tort awards, things of that nature. And yes, it's become a very hot topic.
Now, ultimately, our goal probably of the legal system is to try to get as close as we can to what's known as the rule of law.
That's exactly right.
Tell us a little bit in more detail. People might hear that phrase used often, like, oh, we need to make sure we have the rule of law, or sometimes the rule of laws and not men, or so forth. What exactly is involved in the rule of law? Yeah,
so again, the rule of law is just this idea that it's really law that dictates and governs over anything. Again, as you suggest, it's really the rule of law over the rule of men, where we don't want individuals acting arbitrarily or based on whim about how they feel things should be. It's rather just stable and predictable rules and laws that govern individual behavior. And so really the rule of law there's three major components that make it up. It's that laws are prospective and not retrospective. I think we have it right up here on the screen. Laws must also be known and certain. And then they also need to be equally applicable to all individuals. The important part of that being those individuals, whether it be private individuals or public individuals, meaning that even government officials must also be held accountable to the law.
And this is a huge part of the whole notion that we're going to live in a society where we don't have might make right, but rather that we have rules, and we have rules of justice, and they apply to everybody, right?
That's right. The most important is that they're equally applicable to all individuals, regardless of who those individuals are. Even the individuals making the laws, they're beholden to those laws as well.
Now, eventually, we get into then the issue of tort abuse and whether we need to have tort reform in the United States. But I'm not sure necessarily all of our viewers might know exactly what is meant by the tort law as opposed to, say, criminal law or, say, the rule of contracts larger. So what's the role of what is exactly a tort? What does tort law involve?
Sure, yeah. Tort is, we can think of as just a civil wrong that generally imposes some sort of cost or loss or harm on an individual that didn't want to bear that loss or harm. So the purpose of tort law then is to go about actually compensating that victim for the loss or the harm in order to make them whole again. That's the entire purpose of tort law. You can kind of contrast that with something like criminal law, where ultimately the purpose of criminal law is that there are certain actions and behaviors that we deem inappropriate or undesirable. So criminal law then actually punishes those behaviors in order to deter them as much as possible.
And then there's also contract law, which would involve if two parties already have some kind of an agreement with a contract, and then if there's some dispute that arises under that, that falls under the heading of contract law. Is that right?
That's exactly right. Yeah. So if contract law or if contract disputes arise, something in the contract comes up that we didn't foresee, anything like that, or just you don't fulfill your end of the bargain, then we have laws governing how we go about actually trying to adjudicate and solve those problems.
So probably all three components are important in terms of the rule of law and to have a fair and free society, but it's probably the tort and contract parts that are most important for creating a legal environment for business in a state.
That's exactly right. And most important involved in all of that, again, is having that independent arbitrator, that independent individual to actually resolve those disputes when they do arise, whether it be through some sort of tort, through some sort of contract dispute. Again, that being the judiciary that we have within a state. We want somebody that's unbiased in their decisions, that really sticks to those three guidelines involved in the rule of law and rules based on that, and not their own arbitrary desires or beliefs.
Now, a number of people, we have this ideal of an independent judiciary or a judiciary that could be approaching the rule of law, even though we'll probably never attain it perfectly in any system created by people. But there are some indices that the different groups have put together to try to evaluate or measure different states' legal and judicial systems and see how fair and impartial or independent or effective they might be. And you use one of these in the study you've done for our Improving Life series, right?
Yeah, that's right. It's the Harris Index, which is it's an annual survey now done every 2 years. But when it started for the first few years, it was an annual survey conducted in conjunction with the Institute for Legal Reform. And here we see some of the rankings for various states. But what they did was go out and actually survey a number of lawyers that worked for mid-sized corporations around the country, asking various questions about the states that these lawyers felt knowledgeable in with the laws and existing overall sort of tort system and legal system in those states, asking them how they actually ranked that state overall in, as you're saying, things like fairness, predictability, things like that. And
as here we have the numbers for Alabama, some of our surrounding states, and we have Delaware on there because that happens to be the top-ranked state. But
right.
Alabama doesn't end up doing very well in these rankings, do they?
Yeah, that's sort of been a long-term problem for Alabama, especially now that we actually do have this measure at least to look at. Since 2002, Alabama's ranked near dead last in the ranking. In fact, it was until just about last year that they finally moved from somewhere between 49th and 48th in the country, basically dead last, to I think now they're somewhere around 43 overall. So they have the last year or two really moved up a little bit in these rankings. So we'll see if that keeps trending upward or not.
And Delaware is the top ranked state in this regard. And so in some ways they offer a model of a state legal system that seems to be well designed and enforced for business law, right?
Yeah, they do seem to have something that works within their system that leads to them being ranked #1 overall.
Now, we mentioned that this legal environment for business could be importantly associated with some of the low income in Alabama are lagging behind other states in economic performance. What are some of the numbers that you found related to this?
The numbers overall, generally we see a pretty strong correlation between per capita gross state product, in other words, the amount of stuff that's produced in a state, or we can think of that as being, individual incomes within a state, and also this state liability index overall, sort of the legal quality within a state, where lower legal quality would generally appear to correlate with relatively lower incomes. Higher legal quality in a state would generally appear to correlate with higher incomes, which we see in this chart here.
So the states with the higher scores over there to the right are the ones with the higher incomes, and then
exactly that's exactly
states
right.
with less effective legal systems are having lower incomes. And you find this to be true with other measures of state economic performance as well, right?
Sure. Yeah, I've looked at a number of different measures. Looked at economic freedom, finding that states that have better legal quality scores also seem to be more economically free. Again, that being important because that leads to more gains from trade, opportunities for individuals to get out there and act as entrepreneurs. I've also found that if you look at net business formation within a state, it's generally, again, positively correlated with this legal score, meaning that a higher legal quality within a state would generally suggest that those states also see more business formations, number of measures like that.
So there's certainly a correlation here, and it might well be that a part of the reason why we're lagging behind economically some of the other states in the country is due to our legal system.
Very much so, yes. Yeah.
Now, it's probably unfortunate if if your physician gives you a diagnosis that you have a serious illness, but it's even worse if that diagnosis comes with the with the statement that, well, there's really no effective treatment for this. But at least in the case of our judicial system here in Alabama, there are some reforms that we can undertake, and you recommend two in your study. So what are the two reforms that you think we should undertake? Yeah,
the two reforms, the biggest one that I really want to emphasize is reforming the judiciary itself, and think about actually finding a different way to select judges. Again, that's the biggest one, because as we've been talking about, really one of the cornerstones to the rule of law is to have an independent judiciary. Somebody that can just adjudicate and resolve disputes in an unbiased manner, which unfortunately in the state of Alabama, we select our judges through partisan elections, which has been found time and again to be one of the least independent methods of selecting judges. Ultimately the issue there, and I'm sure we'll talk about more in a second, but the issue really is that when you have that situation, you end up with judges that are, just friendly toward one group. You might have judges that are, business friendly or plaintiff friendly, lawyer friendly. The issue is we don't want that. What we want are judges that are rule of law friendly. That's really what sets up the long run stability and predictability. And then along with that, also thinking about actually reconsidering some of the liability rules that we have in place. One of the biggest being joint and several liability.
Okay, so let's get to this issue of judicial elections. Now, Alabama has elections, as you mentioned, and we also have what are known as partisan elections for judges as opposed to nonpartisan elections. Now, there are clearly some alternative ways we could select judges because, after all, the federal court system offers one example of this. So what are some of the different ways we could, alternatives to Alabama's partisan or party-based or Republicans and Democrats running for the judiciary? What are some of these alternatives that we could?
Right, yeah, so again, there is partisan elections, which is what Alabama uses. It's one of 7 states that does. So again, it's just a situation where citizens elect judges, and those judges run as either Republicans or Democrats. Some states also employ nonpartisan elections, which is, again, it's still just citizens vote for judges, but then those judges, they don't run as any party. They're unaffiliated. You also have the other 2 major methods of selecting judges are appointment and then also what's known as merit selection, where appointment is usually it's the governor. It'd effectively be similar to the federal government, where the government might select a judge, or the governor might select a judge, and then from there, sometimes some states require the state legislature to approve, which is like the federal government, and then also merit selection, which generally requires what's known as a nominating commission to recommend a group of individuals to a governor who then selects from that list. The state legislature, again, generally approves or disapproves whoever the governor selects. And then after that, so there are all kinds of checks and balances under merit selection. From there, those judges generally face retention elections periodically.
Now, what is a retention election?
Yeah, sure, great question. A retention election, it's an unopposed election where citizens have the opportunity in an up or down vote to decide should this judge remain on the bench or should this judge be removed from the bench.
Now, we have these election options in many of the states. In the federal government, we have appointment, and then federal judges serve for life tenure.
Right.
And certainly, many people point to the U.S. Supreme Court and have criticism of it, in that those judges are just on the bench, and once they get appointed to the Supreme Court, they're there for life. They can do whatever they want. They can enforce the laws as they see fit. They can, in effect, create new constitutional rights, which some people claim, like this is back in the day of the Warren Court, that the Supreme Court was doing. And it seems like appointment, the federal system of appointment isn't by any means a perfect system of preventing judges from behaving badly, if you want to think of it that way, right? So what is it about elections that seem to lead to even worse outcomes than, say, appointment?
Sure. Yeah. Again, the issue with elections is, I think we've talked about this quite a bit, but really, again, when we think about elections, especially for judges, is that, look, any elected official, a politician, anybody like that, reacts to the incentives and constraints that they face. Well, judges will be the same way. They'll behave in the same manners as any other politician will if they face elections, meaning, the incentives that they face is they want to serve as a judge. Well, in order to do that, you need enough votes, right? You need 50 plus 1. So given that, judges will be more likely to rule in manners that might be favorable or desirable by constituents. Of course, that doesn't necessarily mean that they're going to be ruling based on the rule of law. It's just what do voters want. That may not be mapped very well. Also, in order to get elected, you also need contributions. You need to be able to finance your campaign. So many times, and especially what we see in the state of Alabama, is that you have a lot of outside special interest influence financing these campaigns. In Alabama, it's generally trial lawyers and then business interests that finance these campaigns. And the end result being that many times these judges have a real incentive to rule along the interests that are supporting them.
And what sounds like is underlying a big part of this is that although we all benefit from the rule of law and judges who are fair, most, that's a public good benefit. And so what's going to happen is that all of us can enjoy the public benefit of judges when they do apply the rule of law effectively, but it's the people who have a dog in the fight who are really going to look to be supporting the judge either through votes or campaign contributions, right?
Yeah, that's exactly right. And I mean, that's really what we see is that more often than not, when you do have influences like that, judges will respond. Judges do respond according to those incentives, voter interests and special interests and the desires that they have.
And this ends up showing up in this study that, or in the index that you were looking at, right? I mean, compare how the state legal systems stack up against each other by their methods of judicial selection. That's explaining a big part of the difference.
That's exactly right, and that's what we're looking at right here, where 3 of the major subcomponents of that legal quality index are made up of judicial competence, impartiality, and then obviously I look at just the overall legal quality. But we see here that top bar there, that's the score for each one of those states that elects judges along partisan lines. And as we see, it's significantly lower. Each one of those measures is significantly lower relative to all other methods of selecting judges. And as you suggested, right, I mean, there's no perfect method to select judges. There's no perfect way or way to completely get bias out of the court system and have a completely independent judiciary. But there are better methods than especially what we currently have.
And in public choice, we're both public choice economists, I guess, by training. But a part of what we emphasize in public choice is that officials, including judges or would-be judges, are going to respond to their incentives. And in the case of state judges, that particularly ends up leading to one maybe perverse incentive when it comes to justice, and that's perhaps favoring in-state residents as opposed to out-of-state interests, right?
That's exactly right, and there's been several studies that have looked at this, and again, this is a great quote to kind of show, at least anecdotally, what you're trying to bring up, which it comes from Richard Neely, the former Chief Justice of the West Virginia Supreme Court, which is again is another state that elects judges along partisan lines. He says, as long as I am allowed to redistribute wealth from out-of-state companies to injured in-state plaintiffs, I shall continue to do so. Not only is my sleep enhanced when I give someone else's money away, but so is my job security, because the in-state plaintiffs, their families, and their friends will re-elect me, which again cuts completely against this idea of judging and ruling based on the rule of law, where now we're sort of reacting to just the incentives that we face.
And any would-be judge is going to face those same incentives. So there's the idea of like, oh, somehow we just need to find some better candidates for our judgeships. That's not going to really cut it here.
That's exactly right. And I mean, you see time and again, and a major study actually looked at the tort awards that went to in-state residents against out-of-state businesses in states that do elect their judges along partisan lines, and found that the average tort award was almost $1 million. It was $960,000 higher than any other state. Again, the incentive being is I can redistribute lots of wealth to citizens who are voters during my elections, and redistribute that from individuals that will have no impact on whether I'm reelected or not. So it's costless for me to do that, though it is, and it benefits those select citizens, but at the detriment to overall economic growth and well-being.
You also mentioned your other element of reform would be to modify our system of liability, what's known as joint and several liability. Right. So most of us aren't lawyers, so if you could, before we get into this, talk a little bit about what is this joint and several liability, and what type of circumstances or cases is it applying to?
Sure. I'm not a lawyer either, but I'll try my best here. The joint and several liability is ultimately a situation where if I find myself in an accident and there are multiple people that caused this accident and caused injury on me, I can sue all of those individuals. Now, each one of those individuals, what the court will try to do is determine, well, how much was each one at fault? So did one person cause 40% of the damage and another person cause 60% of the damage? If that's the case, under normal circumstances, then that individual that caused 40% will compensate me the 40% damages. The other person will compensate me the 60%. Now the issue where joint and several kicks in is if you have a situation where one of those individuals may be unable to pay, effectively what's known as judgment proof, then you have a situation where the other person that can pay would be responsible for the entire 100%.
And what's sort of like the idea behind allowing this rule in the first place?
Well, I mean, again, it goes back to the whole idea of why we have torts, which is you've caused me some sort of harm or some sort of loss, and we want to compensate individuals and victims for that loss. So if you have a situation where multiple defendants or multiple individuals that cause the injury, well, you still want to make that person whole again. So the reason behind that would be if one person can't pay, well, you can still be made whole by forcing the other individual to pay you.
But this ends up having some bad, adverse consequences for the business environment, especially if you're a business operating in a state with this joint and several liability. How does that happen?
Yeah, sure. And again, this is an important point that I'm really trying to draw out in this chapter, is just to understand that there may be many benefits, as we just talked about, behind joint and several, but there are also costs too. And I think that's something that's kind of gotten lost in the debate overall. So what I really want to do is just try to point out some of those costs. Some of the biggest ones are that what we see, especially in the academic literature that's really looked into joint and several, is that overall employment in a state is generally lower. So usually moving away from joint and several increases employment by about 1%, which in the state of Alabama would be about 20,000 jobs. We also see that larger corporations and larger businesses are generally less willing to enter into contracts and business agreements with smaller companies. The reasoning being that it's quite possible that if a lawsuit does arise, the smaller company may not be able to cover the damages, meaning that even if the larger company is only 1% at fault, they could pay the entire 100%. The problem with that is, when we can't contract like this, then firms or businesses are unable to really capitalize on cost efficiencies, which generally means that at the end of the day, we see higher prices overall.
So it ends up creating joint and several liability, the way it is, ends up creating extra uncertainty, especially for larger businesses if they try to contract with smaller businesses, right?
In many instances, yes, that's exactly what we see, and that's again what I try to draw out in my chapter, and really what the academic literature has shown overall. What
would be an alternative then to joint and several liability?
Sure. A couple of alternatives. One could be just pure several liability, where, okay, if you're 40% liable and the other person's 60% liable, that's all you pay. Or you could have something where joint and several liability kicks in if a certain threshold is met. In other words, if maybe one person is 51% liable, then they may bear the entire cost. Whereas if they're only 49%, then that's all they bear. Something along those lines.
Okay. Well, I think this has been a really interesting discussion. Do you think that there's much possibility that these reforms are going to be enacted anytime soon?
Unfortunately, I'd like to say yes, but I'm not too sure about that. These are really just long-run goals that I'd like to get on the table and at least have people talking about and thinking about.
No, I think that's an important part of our project here. So we're trying to set a vision for the future. I mean, to show people the direction that we think that the state needs to be heading. Well, John, thanks very much for coming on. I think it's an interesting topic, and I think a very important one if we're going to try to improve our state's economic performance. And thank you for joining us. Join us again next time for another EconVersations.